Welcome to the Deep Dive. We take your sources, dig in, and pull out the key insights. Today, we're looking at a set of documents you shared, legal opinions, timelines, notes, all zeroing in on a really specific but crucial question.
Right. When those termination notices went out, who was actually your employer?
Exactly. Was it RBC Royal Bank, the bank that hired you, or this other entity, Enterprise Services, that actually sent the redundancy letter?
And critically, what does the legal analysis in these documents say about your employment status right now? Because that's the core puzzle here.
It really is. We've got individuals, specifically officers in RBC's Security Operations Department, getting these redundancy notices. But, well, the sender wasn't the name on their original contract.
Which, throws up all sorts of legal flags around corporate identity, employment contracts, and who actually has the right to end that relationship.
Okay, so let's unpack this. Our goal here is to really understand the players involved, according to your sources, why the termination itself is being questioned legally, and, crucially, what the analysis concludes about where you stand now.
All right. So setting the scene from the documents. First, the employees. That's you, Andrew Bernard, and others in the same boat. The sources state very clearly your direct employer, the one you signed with for the security ops job, was RBC Royal Bank.
Got it. Clear employee-employer relationship with RBC Royal Bank on paper. But then the big event, you get these letters, redundancy notices.
Yes. And right away, the sources highlight this major inconsistency. The letters didn't come from RBC Royal Bank.
Where it came from?
Enterprise Services. And that's the immediate red flag. It's not the entity the sources identify as your employer.
Okay, contract with RBC, letter from Enterprise Services. So what does the legal deep dive in these papers say about that? Can someone else just end your contract?
Well, this is where we get into the main legal opinion you provided, the one dated May 21st, 2025. The primary argument it makes, the reason this termination is questioned, comes down to something called lack of contractual privity.
Privity of contract. Sounds technical. Break that down for us. How does it apply here?
Think of it like this. A contract is basically a private agreement. Only the people or companies who signed it are bound by it and have rights under it. They're the only ones in the club.
Okay.
Your employment contract, according to the sources, was between you and RBC Royal Bank. That was the club.
Right. So where does Enterprise Services fit in?
They don't. They weren't part of that original agreement. They didn't sign the contract. So based on that core principle of privity, Enterprise Services had, zero legal authority to step in and terminate your contract with RBC. It wasn't their contract to end.
Wow. So the legal opinion essentially says that letter from Enterprise Services was legally meaningless because they weren't a party to the contract.
That's the core argument, yes.
Yeah.
But it doesn't stop there. The sources also bring up another really important point, the issue of transferring employment.
Transferring employment. You mean like if RBC had somehow passed the contract over to Enterprise Services?
Exactly. If Enterprise Services was supposed to be the new employer, there needed to be a valid transfer, sometimes called novation or assignment in legal terms.
And I imagine that involves the employee, right? You can't just be transferred without knowing.
Absolutely. The sources really stress this. Employment law generally requires the employee's explicit consent to transfer their contract to a new employing entity. It's fundamental. You have to agree to work for someone new.
Makes sense.
And the documents you provided, they state there was just no evidence of that happening. No sign of employee consent, no formal transfer agreements, nothing showing you were even notified that your employment was moving from RBC to Enterprise Services.
So no consent, no documented transfer. What happens when Enterprise Services tries to terminate without that?
That's where another legal term pops up. Ultravirus. It's Latin.
Meaning?
Beyond the powers,
Yeah.
acting without legal authority. Since Enterprise Services wasn't the employer and there was no valid transfer documented, their attempt to terminate your contract was, according to this analysis, ultravirus.
Acting beyond their powers, and if an action is ultravirus.
Legally, it's often considered null and void, like it never happened in the eyes of the law. The sources cite legal principles, precedents from the Caribbean, T&T industrial court principles, even cases like Western Excavating v. Sharp, all supporting the idea that you can't just have some other company jump in and terminate your employment contract, especially without a proper transfer and consent.
And I noticed Source 8 mentions specific laws, too, like the Industrial Relations Act and the Retrenchment and Severance Benefits Act.
Yes, good point. Source 8 notes that these laws have specific requirements about the contract of service and things like consultation and notification. The argument there is, if the entity doing the terminating isn't the actual employer on record, the whole process fundamentally fails to meet those statutory requirements. It's another layer invalidating the action.
Okay, so let's pull this together. The termination letter from Enterprise Services looks legally void because of privity, no valid transfer, ultra-vires actions, and potentially failing statutory requirements. So what's the bottom line from that May 21st legal opinion? What's the status of the affected officers now?
This is really the crux of it, repeated across the sources. Because the termination notice didn't come from the actual employer, RBC Royal Bank, and because no lawful transfer to Enterprise Services seems to have occurred, the legal conclusion presented is stark. Your employment contract with RBC Royal Bank was not lawfully terminated.
Let me just process that. The legal take in these documents is that even though you got that letter from Enterprise Services, you, Andrew Bernard, and the other officers are, legally speaking, still employees of RBC Royal Bank.
That is exactly what the legal analysis concludes based on the information provided in your sources. The action by Enterprise Services didn't legally sever the employment relationship with RBC.
That's quite something. So the main legal case seems clear based on these sources. Invalid termination, still employed by RBC. But hang on, you mentioned another twist, something about what happened after the letters.
Yes, this is a really fascinating and potentially critical issue raised in one specific source, the one titled RBC Retrenchment Employer Identity Dispute. It highlights a major inconsistency in the legal proceedings that followed.
An inconsistency? How so?
Well, we know the redundancy letters came from Enterprise Services, sometimes with co-RBC Royal Bank added. That implies Enterprise Services is the actor. Maybe RBC is just the mailbox.
Okay.
But then, when things went formal filings with the Ministry of Labor, appearances before the special tribunal, court documents, guess who was listed as the employer, the respondent defending the action?
Oh no. Let me guess. RBC Royal Bank.
You got it. RBC Royal Bank Ltd., not Enterprise Services, was the entity responding, filing affidavits, making the arguments in all those official legal processes.
Wait, so Enterprise Services sends the termination letter, but RBC steps up to defend it in court. Why is that a problem legally?
The source argues it's a massive problem. It calls it a fatal inconsistency and a potential jurisdictional breakdown. The core legal principle is that the entity issuing the termination, reporting the dispute, and defending it in court must be the same legal employer. You can't have one entity fire you and another show up to fight about it later.
And if they are different, what's the consequence?
The analysis suggests the whole legal process that followed could be fundamentally flawed. Did the tribunal even have jurisdiction over the right parties if the entity named as respondent, RBC, wasn't the one who issued the notice, Enterprise Services, per the letter? It raises questions about whether the officers were even able to hold the correct entity accountable.
But what about the co-RBC on the letter? Doesn't that sort of link them?
The source tackles that. It argues that co usually just means care of, like an address. But RBC didn't just act like a mailbox. They acted as the principal, the actual employer, in all the legal fights. That action contradicts the implication of the co on the original letter, muddying the waters even further.
So this whole mismatch, who fired versus who defended, creates a completely separate line of attack on the validity of the ministry certificate, the tribunal process, everything that happened afterwards.
That's precisely the argument laid out in that source. It suggests this procedural mess, this identity confusion, is potentially enough on its own to challenge the entire downstream legal process, arguing the tribunal might have lacked jurisdiction because the party initiating the action wasn't properly represented or identified in the proceedings.
Okay, this is layers upon layers. So we have the initial termination validity issue and this procedural identity crisis. Given all this, what kinds of legal claims do the sources suggest might be possible?
The analysis points to a couple of key potential claims. One is for constructive dismissal.
Constructive dismissal. Remind us what that is again.
It's when the employer doesn't outright fire you, but they change the fundamental terms of your job so drastically without your agreement that it essentially forces you out or shows they no longer intend to be bound by the original contract.
How does that fit here if the termination letter itself was supposedly invalid?
Well, the argument could be that having a completely different entity, Enterprise Services, issue a termination notice, particularly without any prior notification or consent regarding a change in employer, is itself a fundamental unilateral change imposed by the actual employer, RBC, by potentially allowing this confusion. It fundamentally alters the understanding of who you work for, potentially breaching the core trust and confidence required in an employment relationship, thus amounting to constructive dismissal.
Interesting angle. What about just straightforward wrongful dismissal?
That's the other major one highlighted. Wrongful dismissal is basically being terminated in breach of your contract or the law. Since the legal analysis concludes the termination attempt by Enterprise Services was legally void because they weren't the employer and lacked authority, it means the actual employer, RBC, failed to lawfully terminate the contract. Any action relying on that void notice would itself be wrongful.
So you could argue both. Constructive dismissal based on the confusing actions and wrongful dismissal because the termination wasn't done properly by RBC.
The sources certainly suggest both are potential claims to explore, yes, along with general breach of contract claims, seeking remedies like getting your job back reinstatement or financial compensation for the damages suffered.
Okay, it's a complex picture with potentially strong arguments. So based on everything in these documents, what are the concrete next steps recommended for you and the other affected officers?
The sources, particularly the formal legal opinion, are quite specific. Step 1 is to go directly to the entity the analysis says is still the employer.
Which is RBC Royal Bank.
Correct. Send a formal letter straight to RBC Royal Bank, ask them point blank to clarify your employment status, and demand they explain the legal authority under which Enterprise Services issued that termination notice. Put the ball in their court.
And if RBC doesn't give a satisfactory answer or just denies you're still employed?
Then the sources say, escalate. Issue a pre-action protocol letter. That's a formal warning shot, laying out your claims, wrongful dismissal, constructive dismissal, and what you want, like reinstatement or damages, before you actually file in court.
What about the official channels, like the ministry or the court?
Definitely part of the recommended strategy. File formal complaints with the Ministry of Labor and potentially the Industrial Court, outlining the unlawful termination based on all the arguments we've discussed, the wrong entity, lack of authority, etc.
And given there's a group of you?
Yes, the sources strongly recommend considering a group legal action. Since the facts seem similar for multiple officers, pooling resources and presenting a united front could be much more effective.
Now, that other source, the one focused on the inconsistency in the legal proceedings, does it suggest any different or extra steps?
It does, and they're focused specifically on that procedural flaw. It recommends demanding the actual Ministry of Labor filings to see exactly who RBC or Enterprise Services reported the dispute initially.
Why is nailing down that specific fact so important?
Because if RBC reported it, acting as the employer, when the termination letter came from Enterprise Services, it strengthens the argument that the whole ministry and tribunal process was fundamentally flawed from the start due to the wrong party initiating or responding. The source suggests using this inconsistency, this jurisdictional breakdown, as grounds for a constitutional petition, arguing it constitutes a denial of protection of the law.
A constitutional petition? That sounds serious.
It is. It frames the issue not just as a labor dispute, but as a violation of fundamental legal rights to due process and having the correct parties identified in legal actions. That source also suggests formally asking the registrar of the court or tribunal how RBC was allowed to represent or act legally when the initial action seemed to come from Enterprise Services.
Okay, so let's try to wrap our heads around this. What's the big picture takeaway from this deep dive into your sources?
Well, the clearest message is that according to this legal analysis, the situation is far from straightforward. You were hired by RBC Royal Bank. You received a termination letter from Enterprise Services.
And the strong legal opinion presented is that because Enterprise Services wasn't party to your contract and no valid transfer occurred, that letter was likely legally ineffective, which leads to the conclusion
that your employment contract with RBC Royal Bank wasn't lawfully terminated. Based on this analysis, you legally remain an employee of RBC.
But then there's that critical second layer, the procedural issue. The fact that the entity sending the letter, Enterprise Services, seems different from the entity defending the action in court, RBC Royal Bank.
Right. And that inconsistency, that potential fatal flaw, as one source calls it, creates a whole separate challenge to the validity of the legal proceedings themselves. It raises serious questions about jurisdiction, due process, and accountability.
It's a really stark reminder, isn't it? In complex corporate structures, knowing precisely who your legal employer is and who has the authority to act is absolutely paramount.
It really is. And it leaves us with a lingering thought. How often do these kinds of internal corporate changes, or perhaps confusions, impact the fundamental legal standing of employees without them even realizing it until something like this happens? Definitely something to ponder as you consider the next steps outlined here.